Sir, may I request you to kindly start with the second session?
So this session is about construction and infrastructure contracts. And the two aspects which are to be highlighted here are dispute resolution clause and dispute resolution mechanism. Of course, I will, in the process while dealing with these aspects, try to give a holistic view of these construction contracts and 360-degree views so that it becomes important to then understand the importance of these two aspects as well. Now, the first is that when we talk of construction and infrastructure contracts and the disputes that may arise and dispute resolution clause, etc., when it is said, normally here again, of course, I will specify which are the various modes of dispute resolution in such contracts. But arbitration remains the most suitable as well as which is in demand as well, most preferred, I would say, mode of dispute resolution among the parties in contrast with the court dispute. When we talk of arbitration, and if it is arbitration, and of course before that, as I said, and I'll deal with that, there are sometimes different mechanisms which are provided. It may be arbitration, it may be some set boards, etc., under the arbitration or dispute resolution clauses, that before you go to the arbitration, so utilize those fora. But the question is when it is arbitration and those alternate dispute resolution mechanism which is provided in whatever form, why we give a separate or independent entity to such construction and infrastructure contracts or the dispute resolution. It is like any other commercial dispute. ADR, which is applicable there, is applicable here also. But it is not so, if I may say so. There are some peculiar features of construction cases, and therefore those have to be kept in mind. But before that, what is the meaning of construction contract? What kind of contract qualifies as construction contract or infrastructure contract? In common parlance, we may say that any contract which relates to construction of a particular project or some infrastructure project, etc., it is a common understanding, no doubt about it. But Accounting Standard 7, which is issued by the Chartered Accountant Institute, it has defined a construction contract as a contract specifically negotiated for the construction of an asset or a combination of assets that are closely interrelated or interdependent in terms of their design, technology, and function, or their ultimate purpose or use. So they are normally treated as, these are defined as construction contracts or infrastructure contracts. Then, as I said, what is that? Which are their peculiar features which make construction and infrastructure contracts distinct from other types of commercial contracts? You see, number one, these are very, very highly technical in nature, which may not be, maybe, but may not be in other types of cases. Take the example of construction of a shipbuilding, construction of oil rigs, and construction of course, buildings, but very big projects, colonies, colonization is done, or say housing project for cooperative housing societies project. It may be commercial complexes, like we know these, you go to all these malls, etc. big hotels, as I've already said, townships, hospitals, national highways, even airports, construction of airports, all these and sometimes industrial establishments. Now, these are very, very big construction contracts which are there. And the construction of each is of a different nature, which is very, very technical in nature. Like if it is a shipbuilding, a totally different kind of technique is required. Oil rigs, if you see the contracts which are there of ONGC in respect of oil rigs and oil exploration, etc., totally different kind. And the construction of buildings, even among buildings, if it is commercial complex, it is different connotation or different kinds of skill. For hotels, it is again different. For township, again different. Hospitals, again different. And I have, I mean, as an arbitrator for last 3 years, decided, or is some arbitrations are going on also, which cover almost all. Shipbuilding, I have not so far, but oil rigs, I have about township, hospitals, hotels, commercial complexes. And I find the contracts which are entered into are of a totally different nature. And many times, in order to understand the implication or in order to understand the technical aspects, one has to really labor a lot. And so therefore, that is first reason which makes construction and infrastructure contracts as a distinct category from other kinds of contracts in respect of which the disputes may arise. Another important from the economy, etc. Point of view is concerned, you see, construction in India is today the second largest industry after agriculture. Construction of infrastructure, particularly highways and even these oil rigs and even shipbuildings and other airports, etc., which I have said, that is very, very important for the growth of any economy. And you know, as far as highways are concerned, NHAI, National Highway Authority of India, is constituted for this particular purpose. Civil aviation and for airports, etc., we know that Airport Authority of India has been constituted, which is taking care of that. And as far as oil rigs, etc., are concerned, as I said, ONGC, Oil India Corporation, they are especially, I mean, these companies have been incorporated to take care of that. And what I'm trying to emphasize here is that because of these reasons, much importance is given, and it will have its repercussion on the dispute resolution clauses and dispute resolution mechanism. Not only importance is given, they are very, very necessary for the growth of the economy. And it is because of this reason, if disputes arise, now two things which have to be taken care of. There may be, because such contracts, when they are given, they are not to be, these contracts are not performed within few months or so. In some cases, it may take years when the project is completed, because these are very, very big projects. It may take 4 years, 5 years, 6 years, even 10 years, even more than 10 years. Now, contract is awarded either by NHAI or ONGC or any, let's say, airport authority for construction of these particular projects to a particular contractor, and it is going to take long time. In between, some dispute arises. So question is, because of that dispute, whether the contract should come to an end? No. Purpose is, if dispute arises, dispute should be settled, no doubt. But in the meantime, the contract and that project should go on uninterruptedly. And therefore, these kinds of special clauses are normally put in these contract cases also, because that is the aim. And if the dispute has arisen, it may be some particular job which is done, which was not prescribed in the contract. Question is whether it is additional job for which the contractor has to be remunerated, or it is a part of the contract itself, for which the contract price is already mentioned, dispute may arise. Dispute may arise about the specifications, etc. But and disputes generally which arise, and I'll come to that, are on account of delays, because many times these are in the contracts. You will find time is the essence of the contract. That clause would also be always be there, whether it is to be executed in 3 years, 5 years, 7 years time, that is stipulated. But it always overruns for various reasons. I'll indicate in brief at the relevant time, sometime later. But what I'm trying to say is that the delay, because of the delay, costs are escalated. What was decided or what was thought that within 3 years, if a particular contract is to be completed, and if it has taken 5 years or 6 years, contractor would say that, look, delay is on because of the employer, that is the person who has given the contract, the authority, and I am not responsible, but my cost has escalated, you pay. Contractor may, this employer may say, sorry, delay has occurred on your part. But then this dispute may go on, and dispute should be decided immediately, so that the relationship between the parties are maintained and they go on with the contract. Even if it is delayed, project should be completed. That is another very, very important, that yes, the relationship should not be spoiled. Issues may remain, and therefore when the issues arise from time to time, they become subject matter of arbitrations. And many times, another peculiar thing of these construction contracts is, out of one contract, sometimes there is 3, 4 or 5 or 6 disputes and 6 arbitrations which go on. I am doing one case of such a contract, construction contract, which is the 4th arbitration before us. 3 have already been done earlier by some other tribunals, etc. But because disputes are different and the project is still going on. So these are some of the very interesting issues. And then another thing is that in almost all these cases, whether it is shipbuilding, oil rigs, or hotels and hospitals or commercial complex, etc., now many times FDIs invited, foreign direct investment. So therefore, foreign players, they come. They may give their capital, they may infuse money, or they may give the expertise, technology, etc. for these purposes. So dispute may arise, and because of the FDI, it assumes the dimension of an international arbitration or international dispute if it arises between the parties. And normally, because of, as I've said, that these big projects, which infrastructure project, government is the party or government authorities are the parties. So therefore, these are some of the peculiar things which are there. And we have to keep in mind that understand the infrastructure, that there are many kinds of models in which and they will have repercussion on the disputes. Many kinds of models of the contract which have come into play or which are in vogue. If you all must have heard the expression which we started again after the liberalization, etc. If you see, most of these industries which I am telling you, whether it is civil aviation, whether it is rigging of oil, etc., oil rigs, or it is shipbuilding, most of these were earlier with the government, with government monopoly, with whether it is telecom sector, whether it is insurance sector. But after the opening of the economy, after liberalization, it is all now private parties which have come in all these sectors. But the government also needs these projects, as I have said. So with the what was started was what we call PPP, private-public partnership, where the government and the private sector, they come together and develop a project. A particular highway is constructed, say from Panipat to Jalandhar. Now that is constructed, that is given to the private party, and that may be constructed by that private party. And then after that construction, what is done is that, okay, now toll the vehicles which will pass through can be collected, toll charges, etc. are fixed, and for 20 years, 15 years, 30 years, that rights are given to the private party, that you have constructed, you have invested your money, now you can realize and make your profits by earning through this means. And after that 20-25 years, you will give back that to the government, and the government will have right either to discontinue the toll or to collect the toll or give it to somebody else. So these are, on that basis, actually, the kind of the projects or this PPPs contracts which have come, types of the contract which are there. I would just because the disputes would be different depending upon the contracts. One is called building, own and operate. Build, own and operate. So power is given by the government to that particular private party. You build, you own also, you operate also, you maintain also. Everything is there. Other is build, operate, own, operate, and transfer. First was BOO, then it is boot, BOOT. But you will build, you will own, you will operate, but for 20 years, 25 years, thereafter you will transfer back. Then build, own, and transfer. Again, this is the most popular type of concession agreement. These are called concession agreement, and the person who is given the contract, they are called concessionaire. You must have heard this, that for the duration of the contractual agreement, the private party is responsible for project finance, construction, operation, and maintenance. During the operation phase, the private company recoups its construction cost, operation and maintenance charges by charging fee, controlling tolls, or renting out the space. Following that, a fully working facility is given to the government at no cost. Now, third is build, transfer. Another is build, transfer, and operate. So you can build it, you can then transfer, and the government transfers to do, and you operate it for specified period. Then DCMF, design, construct, manage, and finance. Then engineering procurement, this has become very popular, which I am coming to. This is called EPC, engineering, procurement, and construction. So the methodology which is utilized is to develop infrastructure project, particularly motorways, again highways. The government entity pays. It is a government entity which is paying for all raw material purchase, building expenditure, and other expenses. The commercial entity, that is a private party, its involvement is limited to providing engineering technology, that is engineering and so procurement, etc. is by the government, engineering by them, and they jointly construct. Then other is hybrid annuity model, HAM, and this model is often utilized for highways project implementation again, and all these are in fact by NHAI, which has come. And the interesting reason for all this also, I will say, they came out with one project, they found that so many disputes are there, they then shifted to other project, third project. So all these innovative methods are because of the experience with by the NHAI on in respect of these projects and the kinds of disputes which have been arisen. So as far as hybrid annuity model is concerned, which is HAM, this project, the cost is split. Okay, 60% will be paid by the private party, 40% by the government, and it will be constructed. And in this hybrid, thereafter the contract agreement will say that it is the government which will collect, but annuity. And every year out of those collection, annuity which is decided shall be given by the government to the private party. So these are various. So in a way, capital is taken or borrowed, or some technology is borrowed, but the government will be operating, government will be collecting, but then paying them and on annual basis some fee which is called annuity. Now, these are different, and every dispute will depend if it arises on what kind of contract is there, and each contract has different kind of, each type of contract has different types of clauses also. Now, what is important is, in such cases, I tell you, and as I mentioned earlier, one thing which is mainly which happens, although time is the essence of the contract, but it is hardly maintained. the contract doesn't get completed within the time which is stipulated. So therefore, these contracts provide for the clauses which call extension because of delay. Now, delay can be on the part of the employer, delay can be on the part of the contractor. There are some delays which may simultaneously be on the part of both the parties, which we call concurrent delays. Normally, what happens is 2 or 3 peculiar things which are in all, and because of that, different kind of disputes arise in contrast with the disputes in other arbitration or other commercial contracts, is that there is a provision for giving extension. But if the delay is, this provisions are normally like this. If there is a delay on the part of the employer, suitable extension will be given, but contractor will not be entitled to any compensation, even when there is a delay. On the other hand, if the delay is on the part of the contractor, extension will be given subject to imposition of liquidated damages. Which are liquidated damages are, pre-estimated damages, which can be specified and which are recoverable under Section 74 of the Contract Act. As you know, Section 73 and 74 are the 2 main provisions where a party has suffered damages because of breach on the other party. Then the party which has suffered the damages will first establish breach, and then will also have to give a proof of how much damages it has suffered. That is Section 73. Now, how much damage and whatever is the actual damage, if it is suffered and they are able to prove, that will be awarded, whether it is in the by the court or by the arbitration. But pre-estimated damages are, which are mentioned and covered under Section 74, that these clauses say that, look, this is the, if the delay happens, if it is on account of delay which we are discussing, the clause regarding liquidated damages say for each month's delay or each week's delay, you will have to pay this much. Of course, subject to maximum of cap is there. 5% of the contract value, 10% of the contract value, etc. That is there. Now, the issue which normally in such cases arise is, and which becomes peculiar and which is to be decided, is whether delay was on the part of the contractor, because we have seen normally both blaming each other. And employer would say contractor did not bring his full resources, did not mobilize manpower and machinery to execute that, or had faulted in one way or the other, and therefore delay occurred. The contractor, on the other hand, will say there are some obligations which were to be fulfilled by the employer. That is, suppose for construction of highway, I was to be given site. Naturally, on which site on which the construction is to the road is to be constructed, but that was not given either, or maybe it was there was it was to be acquired under the Land Acquisition Act, acquisition proceedings delayed, or even if it was acquired, there was some encroachment on that, they could not get it done, cleared, and therefore delay occurred, or say it was passing through say forest or some other, the road was passing, and the either permission from the forest department or permission from the any particular municipal authority or permission of any other kind was to be taken, environment etc., which was not taken or delayed. So all these kinds of some agitation took place, so that it can be there. And of course there can be causes which are not attributed to anybody. It may be what we call force majeure clauses. Say pandemic is this, because of COVID, the work could not be done. Lockdown was declared for 2 months, 3 months, for which neither the contractor is liable nor the employer is responsible. So all these situations arise. But what I'm trying to say is, and which I have seen now, the delays, some delays may not have any impact on the, even if the delay has taken place, may not have any impact on the progress of the work. Suppose, or even if the delay has occurred on the part of the employer may not be responsible because some other corresponding obligation which the contractor had to perform, it has failed to perform. Suppose I give you example that the contract mentions that site was to be given by such and such date, which is delayed by 2 months. Delay is there definitely, but employee is able to show the contractor was to start the work and had to complete some, initial formality like giving the bank guarantees, etc., or signing the contract. And for 3 months, that was not done. So even if the bank guarantee is not given for 3 months, so even if there is a delay of 2 months, that is inconsequential because the contractor could not have, in any case, started the work as it has not given the bank guarantee or not signed the contract. So therefore, but this is very easy example I am giving. But I have told you in these kinds of complex cases where the reciprocal promises are there, on the basis of which whether delay is attributed to the contractor or the employer, or it is overlapping, etc., concurrent delay, which I have said, which is of no consequence, vis-a-vis the delay which has affected the contract, which we call critical delays in the legal language. So it is only the critical delay. All this is not easy, for which normally now in the arbitrations we have found the experts coming who are giving expert evidence. Now, expert evidence is on delay. Then the expert evidence is also the loss which is suffered because of that delay. Quantum, deciding that. Again, very, expertise is required on that. And those expert witnesses on technical aspects, on quantum, delay, technical delay, and on quantum delay, because of that delay. So these expert witnesses are produced from both sides. It becomes difficult. Of course, it has been happening in international arbitrations. From my experience, I found initially, as far as domestic arbitration within India are concerned, lawyers or the parties were hardly producing the expert evidence which is required, because they just will refer to some document that because I have been writing these letters, delay occurred on their part. The other side say I'll be writing these letters, delay occurred on their part. But it is the tribunal or the court which has to decide what is the critical delay. And so maybe the project is delayed by 3 years. Out of these 3 years, 2 years were concurrent delay. Only 1 year was critical delay. But then out of these 1 year, some was on the employer, some was on the contractor, but which was say 100 days on the part of the employer, 200 days on the part of the contractor. So ultimately, it is 100 days which is affected, and the employer can ask for LD, etc. for these days. All these become technical issues. So one is the issue of these delays, which become very, very important in these cases. And other is, as I told you, if the delay is on the part of the employer, and many times clause says in that event you will be only entitled to extension of time and not the and not any compensation. The question which arises is, and contractor says, sorry, because of this delay, I had to, my manpower was there, my machinery was there, there was a loss of profits also, because I would have taken it somewhere else, and I have to, here the cost has escalated, so it is a breach on your part. Under Section 73 of the Act, I am entitled. Employer says, sorry, it was very clearly agreed, this clause very clearly says, and you don't have right to claim any compensation, but you can only claim the this extension of time. Now, these there are judgments that the parties are bound by the terms of the contract. Now, what to be done? These are called exclusionary clauses, in the way where the right to claim the compensation is excluded. But I'm not going into that jurisprudence today. There are much law which has developed and very thorny issues which have been arisen on both sides. But for your benefits, many times when the cases come, I have given few awards on this and tried to analyze. And on that basis, in somebody's coming out with a book, at those editors, so they asked me to write an article. So I have written precisely on these exclusionary clauses, which I'll share with Dr. Balram Gupta, and he can give it to you so that you can all an entire case law on that, most of the relevant case law, and what is the way out. On the one hand, when the contract says no damages, on the other hand, law provides for damages. So which way to go, and how the courts have deemed mostly in favor of statutory right to claim damages. So all these aspects are there, and I would refer to those. I mean, Dr. Balram Gupta, I'll send you. I'll immediately after this, I'll mail that article which you can circulate, which contains all those, because I'm not going into those aspects as our purpose here is about the dispute resolution clause and dispute resolution mechanism. But what I wanted to emphasize up to now was what are the peculiar features of construction contracts and construction arbitrations, which are not in other kinds of arbitration or commercial arbitrations. But then the question is, as I said, dispute resolution clause. Now, what happens if I don't know, you may have read it in the newspaper also. Today, only NHAI has suffered the awards. Apart from other public sector, I don't know. NHAI has today awards against us to the tune of 75,000 crores, which are pending enforcement at various stages. So for construction of these highways, and delays, etc., because of which they have suffered the award. So how much effect or cost effect it can be on the not only infrastructure but on the economy, etc., and ultimately it is the taxpayers' exchequer. So on the exchequer, you can imagine. So therefore, resolution of these disputes. Now I'm coming to dispute resolution clause, and of course I have touched upon dispute resolution mechanism to some extent, but which will follow from there as well. That resolution of these disputes need a special treatment, and dispute resolution clause has to be very, very, innovative in such cases. What has happened? Many times, and the various clauses, various aspects, and which NHAI also, and our present minister, Mr. Gadkari of Ministry of Road and Transport, has also, I've heard him, has spoken at some places, and it has been stated as well that we should try that it reaches the arbitration at the last moment. Of course, court thereafter should not at all, but the dispute should be resolved earlier, before that. And therefore, different types of ADR mechanisms which are utilized and which are contained in dispute resolution clause in the contract itself. Then what is that? And it's as a part of multi-tier dispute resolution, and this is now known to be as MTDRC, multi-tier dispute resolution clauses. So these are today, no. First is, they say, and you will find these clauses which are not normally in other types of contracts, is negotiation. So before proceeding any further, let the parties, and that would be specifically provided, let the parties address the disagreement in a non-adversarial manner, and it entails direct principal to principal negotiation between all stakeholders. They sit across the table. Of course, at the level of the institution or the public sector or the government, very high-powered committees are set up of 2 or 3 persons who are not even given power to settle, but negotiation, etc., so that it is, if there are some genuine claims of the contractor, they should be taken care of at the initial stage itself. After negotiation, next is mediation or conciliation. Now, if across the table we are not able to settle, clauses do provide that will go for mediation. And I have seen, because I have received many times many letters also from some certain public undertakings, that you be our mediator, come on our panel. And at that stage, so that if some dispute arises, we will then they refer to those persons who are on the panel. And what I'm trying to emphasize is that they want good mediators or even retired High Court or Supreme Court judges to be the mediators, those who will do that. And sometimes this is, I mean, other aspect is, yes, if that also fails, then arbitration is there. But apart from arbitration, there's expert determination. Sometimes what happens is, we, in our mediation language also, it is called as ENE, early neutral evaluation, or expert determination. Before the matter goes to the arbitration, the public sector or the employer would like to have, because their officers are taking one stand. They think, so as I've given you the example, a particular work which is done by the contractor says it is an extra work, which is not provided in the contract for which I am paid. So for extra work, I should be paid extra. Or some material which is the specification which were provided. He says thereafter I am asked to provide better quality material. So therefore cost has gone up. I should be given extra for all this. Now the question is, going by the clause or whatever the employer or their officers may think, no, it all comes within the contract for which we have already paid. So whether it is extra work or not, or whether it is higher quality work or not, so I mean, may give rise to a dispute. But why not go to an expert who should give us the opinion at this stage itself? And if we feel that, he may, as I said, it is called early neutral evaluation. He, at early stage, a neutral person evaluates where you stand. So he may say that, look, you may have difficulty. So then it will facilitate, again, settlement of the disputes. And then another technique which is adopted is, and which has become very popular, is either med-arg-med or arg-med-arg. Med-arg-med is mediation. If mediation fails, arbitration. And even during arbitration, we know our Arbitration and Conciliation Act says, even matter referred to arbitrator, the arbitrator can, if he thinks that there are possibility of conciliation, he can refer it for conciliation, or the parties can think that no, they can again go back to mediation in some respects, or arbitration, mediation, and if that fails, again arbitration. So these are various techniques of dispute resolution which are provided. And I may say here and give quote one judgment. It is again of 2019, given by the Supreme Court in NHAI versus Saidabad Tea Estate. In this case, the court was concerned with or dealing with an application under Section 11 of the Arbitration Act for appointment of an arbitrator in relation to dispute with the NHAI. And the question was whether it is Section 11 application is maintainable or not maintainable in the light of Section 3G, subsection 5 of the National Highway Act. You know, NHAI projects, NHAI is constituted under National Highway Act of 1956. And the central government appoints an arbitrator under Section 3G5 of the National Highway Act. This provision talks about the appointment. On the other hand, Section 11 court is given the power. But then the question which was that appointment by the government under Section 3G or appointment by the court under Section 11. So which of the two appointments was valid? The court concluded that the phrase subject to, which is mentioned in Section 3G5 of the National Highway Act, plainly implies that the legislation intended to give overriding effect to the provisions of National Highway Act when it comes into force, and rather than this act, I mean Arbitration and Conciliation Act. And therefore, if the court exercises the power under 3G, that arbitration would be the valid arbitration. So this I was only mode of this resolution of disputes. I wanted to deal with that and to tell you about that. Now here what happens is, as I said, about delay, I have mentioned, I do not want to state much in detail, because as judicial officers, you will be dealing with the enforcement of the awards or challenge to the award which have already been passed. But as far as arbitrators are concerned, it is a difficult job for them of delay analysis, which has the time and time impact thereof, and as I said, delay is critical or uncritical, etc., and how it is to be done. But at the same time, question that arises is another question, which of course courts are concerned with that when it comes to the enforcement or challenge to the award, is about the evidence, the kind of evidence which is to be produced by the contractor before the arbitrator or arbitral tribunal to prove the losses. Now, many times, or in respect of the courts have said, in respect of some claims, it may not be possible to give the direct evidence. Suppose loss which is suffered. It says that for 2 years I could not do. I was concentrating on this project which was delayed by 2 years. So I have loss of profit. Or suppose the contract is terminated prematurely. Full work was not given, and only 50 or 60% work was completed by the contractor. But then the contract stood terminated by the employer on the ground that there is a failure on the part of the, in spite of extensions given, 2 years further extension, and the contractor has completed only 60% work. So therefore, sorry, we are terminating and giving it to somebody else. You are incompetent. And ultimately, the tribunal finds, arbitral tribunal finds, no, delay was not on the part of the contractor, and therefore the contract was wrongly terminated. So question is the loss which the contractor may have suffered for not allowing to do that 40% work. So what kind of evidence is to be? Normally it is that for, as you know, under section 73, evidence is to be produced, but the courts have come out with this, and we call it, you must be knowing, Hudson formula, or there are 3 formulas which have become important, Hudson formula, Emden formula, or Ashley formula. But and the court can, the arbitral tribunal, under the given circumstances, and under which circumstance which formula is to be applied, where even in the absence of direct evidence, some compensation for loss of profit, etc., can be given, and what kind of evidence is to be produced. So this has come for consideration before the court, and I will only give you the judgments which you can read. One is a very famous judgment of the Supreme Court given in 2007 or 8. I think it was a judgment of Justice Sinha, McDermott International versus Bern Standard, where the court has described all these 3 formulas, Hudson, Emden, Ashley formula, and under what circumstances which formula can be applied for the purpose of computing loss of profit, overhead cost for delay, pendentolite, escalation cost, liquidated damages, etc. Why I am emphasizing is because whatever formula is applied and it is given, normally when such an award is challenged, employer can always say that, look, there is no evidence produced. And you will find certain judgments of Delhi High Court, Bombay High Court, etc., which often I am not able to give the citation, where they have said that in the absence of giving evidence, the damages should not be given. So what kind of evidence should be produced, under what circumstances, which formula should be applied, for what purpose it should be applied, etc. All these become relevant for the judges when the award comes for comes under challenge. So these are and other judgment which in this behalf I tell you is you can go to Kailash. This is again relying upon, or rather referring to, or McDermott, Kalashnath Associates versus DDA. It is of, I think, 2017 or 18, authored by Justice Rohinton Nariman, which takes into consideration the entire spectrum and deals with this. Must read these two judgments, which you will be confronted with or concerned with, and you will have to apply the principles laid down while dealing with most of the arbitration, whether they're in construction contract invariably, but even if those are not with construction contract, these two judgment when the awards are given, which will be very, very important for you. As I told you, insofar as exclusionary clauses are concerned, I'm not dealing much with that, and I'll be sending you that that article where all these judgments are. Last thing which I would say, and I'll rest at that, is about the role of the courts, which become very important, and it will take care the kind of approach you should have. There has always been a debate about the role of the court, whether we and this debate always arises as India has not been able to become the hub of international arbitration so far. We go to Singapore Arbitration Center, we go to ICC Paris, and they have office there in Singapore also. We go to Hong Kong Arbitration Center, Dubai International Arbitration Center has come. London, as I said, LCIA is there. Most of the dispute, but when it comes to international arbitration, we hardly have international arbitration. Of course, in those cases where the Indian law is to be applied and seat is in India, so Indian arbitrators are appointed, that's a different thing. But if it is international arbitration, as I told you, normally independent neutral forum is chosen. Say it is between India and England, they may go to Singapore or Hong Kong. But what about if it is Singapore and Germany or Singapore and England? Would they come to India? So far, it has not happened. We have not been able to set up. The first reason which the part normally which is given is by the international community is that, look, in India, the interference by the courts is much as far as arbitration awards are concerned, and delays take place. Now, as far as interference and when it comes to enforcement of the awards, in last 10 years, the Supreme Court has set right the jurisprudence. The message has gone by various judgments of the Supreme Court that no, we are here to, and that arbitration culture has been re-established, which after 1996 Act, for 2 or 3 judgments initially which were given, one was ONGC, Sawpipe, and other was that Bhatia International, etc., which came under criticism a lot, but now those are either overruled statutorily or even by the Constitution bench. But various judgments which have come, if you read in last few years, they are for the enforcement of the award, because what is said is, and I come back to that party autonomy, that if the parties had chosen their arbitral tribunal, the courts are to support the arbitral system. We should have that arbitration culture, which is conducive for the parties. And the courts are not sitting as appellate court, as if they are deciding the appeal. The jurisdiction of the court to interfere with the arbitral award is very limited under Section 34 of the Act, or Section 45 when it comes to 44, 45 when it comes to international arbitrations. And as Commercial Court Act, you will be dealing with all these aspects. So therefore, this is the culture which we have to, and it is very, very necessary. On the one hand, we should have robust laws which are there. 96 Act was passed. Some hiccups were there on the way, but then we had amendments in 2012, 2015, 2019, which have taken care of most of the aspects. Second is enforcement, where role of judiciary comes. And judiciary has to play its important role. As I said, when it comes to enforcement or interference, the Supreme Court has now given a clear message that it should be least only when clear injustice is done and the case is decided which come within the four corners of section 34, etc. But even now we have the problem as far as delay is concerned, whether we are able to enforce it within time. So there, I think commercial court acts, when it was, Act came into force from 2015, main purpose was, and as specifically section 13, which provides for the jurisdiction of the Commercial Court Act to deal with arbitration matter also, is that when the section 34 petition comes or section 37, etc., it's against the arbitration award, matter is before the commercial court, so that we have these specialized courts where the judges are well equipped, well trained, and they are able to decide it as fast as possible. So this is the duty of the judiciary which has to be kept in mind. So with that, I conclude my presentation. Thank you very much.
Thank you, A.K.Sikri. You know, these two sessions have been so engaging and highly contributory with regard to both the aspects which are so significant and important so far as the domain of commercial courts are concerned. I know 2 sessions on a given day to spare was not an easy exercise, and the kind of adjustment which you had to make. Initially, probably it was that the arbitration matters that you had would be in the morning part, and in the afternoon you would be with us. But then somehow in the afternoon, the arbitration got fixed out. That change also you made, and you accommodated us. How should I thank you for all that? Your love for the Chandigarh Judicial Academy has really made these 2 sessions so very important, contributory, and I'm ever grateful to you. Your contribution in future also in our various programs, particularly now we are looking forward to the physical possibility of the programs as such. But this modus of online programs certainly can help us in having the best of resource persons across the country and sometimes even beyond the country. And therefore, we can have many meaningful programs in future in this particular context. Thank you so much, Justice Sikri. We are grateful to you. Thank you.
My pleasure. Thank you. And best of luck, everybody. Thank you.